Human resources officers have long been aware that the National Labor Relations Board frowns upon employer policies barring covered workers from discussing their compensation with one another. Despite the NLRB's position, many companies nonetheless have either formal or informal policies against employees swapping salary information. Even an informal policy can get an employer in trouble, and even in non-union workplaces. That's because the NLRB views such policies as interfering with every covered worker's right to engage in concerted action for mutual aid and protection. Of course, not all employees are covered by the National Labor Relations Act, and such policies are not problematic for, say, managerial employees. At least that's true as a matter of federal law, but several states have long had statutes on the books limiting employers from reprisals against employees for sharing compensation information. The new kid on the block, in this regard, is New Jersey. It has just enacted an amendment to its law against discrimination. NJSA Title 10, Chapter 5, Section 12, which now declares it an unlawful employment practice for any employer to take reprisals against any employee for requesting information regarding the job title, occupational category, and rate of compensation, including benefits, of any employee, or the gender, race, ethnicity, military status, or national origin of an employee if the purpose of the request was to assist in investigating possible discrimination concerning pay, compensation, bonuses, other compensation, or benefits. There's a fair amount of verbiage here, some of which might make a big difference in an actual court case, but the message is clear in terms of practical guidance. An employer should not retaliate against employees for seeking compensation information from HR or from other employees. Admittedly, the statute's protection is limited to requests for the purpose of investigating or filing suit for discrimination in compensation. So, in theory at least, a firm could discipline someone who is seeking such information purely for gossip purposes. But, of course, it makes no sense to expect HR personnel to be telepaths as to why an employee is seeking this kind of information. The New Jersey statute has some peculiarities. For example, it does not explicitly bar employer policies discouraging sharing of salary information. It is limited to retaliation for asking for compensation and related information. But a New Jersey employer would be very ill-advised to retain a policy discouraging discussions about salary information, since it would be Exhibit A in any lawsuit by a terminated employee who claimed the real reason for an adverse employment action was retaliation for such conduct. Second, the New Jersey statute doesn't, at least on its face, protect the providers of such information, simply those who request it. While it explicitly states that no one is required to provide salary information merely because such a request is made, it seems odd that the statute does not protect those who respond to protected requests. Still, given the New Jersey court's broad reading of its anti-discrimination law, it would be foolish to draw such a distinction. A third interesting aspect of the statute is that it can be read to protect only inquiries related to gender, race, ethnicity, military status, or national origin, but not several other protected categories such as age or disability. Again, this is probably not a distinction you want to bet the ranch on. The safest policy is simply not to take an adverse action against employees on the basis that they shared salary information. Even if your firm doesn't have any operations in New Jersey, this amendment might prompt a reconsideration of any policies you may have in this regard. Many commentators feel such policies are largely unnecessary because American employees are acculturated not to discuss compensation in any event. While the water cooler is the venue for discussions of many private topics, what a particular employee is paid remains largely taboo. Given the potential of NLRB interest, safe is better than sorry.